Dear students, in this particular lecture and we are going to elaborately discuss about the risk assessment. So, the risk assessment, we said that in the last the first class, the entire SPS measure is based on scientific evidence and risk assessment. So, it is important to see what is exactly you mean by this risk assessment, how the risk assessment is made and the intricacies of risk assessment and how it is affecting or how it is going to affect the international standard making and what are its implications, and also we will see some of the cases, the case laws which are decided by the panel and other the agencies. And also most importantly we will also see that as a part of the transparency process, the inquiry points. What are the inquiry points in India? What are the other agencies in India dealing with the SPS agreement? And also we will see that what is the function of the Codex, what is this Codex and what is their functions and how they make standards. So, let us first see or discuss about the risk assessment. So, the risk assessment, you can see that, so we saw that there are 3 international organizations which making standards. How they make the standards? They make the standards based on risk assessment. So, the Codex Alimentarius which form food standards and OIE which form the standards for animal health, then IPPC which form standards for plant health. So, these are the 3 international organizations which making international standards mainly based on risk assessment. What exactly you mean by the risk assessment? So, article 2.2 of the SPS agreement which talks about, which clearly says that the SPS agreement is measure, the any SPS measure on scientific principles and not maintained without sufficient scientific evidence. So, who will determine the scientific evidence? So, yes, the members to prove that this particular measure is in accordance with scientific evidence, and this is the risk assessment which is made. So, these standards, so internationally standards can be different for different reasons for members. So, as I told you, so you can see the 3 components, the food safety, animal and plant health, and also the members have the right to adopt SPS measures at a higher level of health protection than the international standards, but that should be based on scientific, again based on scientific evidence and risk assessment. So, scientific evidence must take the form of risk assessment. So, the entire scientific evidence is based on risk assessment, and which you can see that the risk assessment in many cases is the rulings are there from the WTO panel and appellate body. For example, the Australia salmon case. So, the panel very clearly said that the risk assessment must be made on based on economic or establishment or spread of the disease and likelihood of consequences, and assessment of risk, the members should take scientific evidence. Australia Japan apple case, again the appellate body said scientific prudence, scientific evidence, scientific prudence must be displayed by the experts. So, the theoretical uncertainty is not the problem of SPS, and scientific prudence and scientific evidence is the basis of all SPS measures. And also you can see the assessment part, how it is made. So, the assessment of risk, as I told you, so for achieving a particular level of standard or achieving appropriate level of sanitary and phytosanitary protection. This appropriate level should not exceed primarily to protect plant health, animal health, or the food safety mechanism or human health. So, the risk assessment include the risk assessment must be purely scientific in nature. And also you can see that the international standards are made by the international organizations purely based on a risk assessment. So, risk assessment is a part and parcel of the scientific evidence. So, Article 5.1 of the SPS agreement clearly says that the members shall ensure that their sanitary or phytosanitary measures are based on assessment appropriate to circumstances, and risk should be assessed to human, animal or plant life health, taking into account the risk assessment techniques developed by the relevant international organization. So, the standard format is the risk assessment developed by the international organizations, and they do a risk assessment and they come out with an international standard, and mostly the countries adopt. So, for example, countries like India not adopted the Codex standards, a very high standard. Rather, India adopted standards developed by its own agencies, and we will see later on some of the lectures. So, 5.2 also supplements 5.1 and says that the assessment of risk, the members shall take into account scientific evidence and the process and production methods, the inspection methods, sampling and testing methods, special diseases or pests in a particular region or area, the ecological and environmental concerns, and quarantine facilities and treatment. So, it is not very simple. The risk assessment and procedures are elaborate and comprehensive, which is provided under Article 5.1 and 5.2 of the agreement. And what are the different types of risk assessment? So, the risk assessment, the risk to human body, animals and plants are different. So, in the case of human beings, which you can see that the evaluating the potential for adverse effects arising from additives, contaminants and other hazardous substances in food. So, it may be a pesticide residue, it may be additives, it may be contaminants, or it may be salmonella, contaminants like salmonella. So, or it may be even it's named as filthy. So, this is a high risk to the human beings. And then the entry of pest, if you come to the plants, you can see the entry of pest and diseases to a country is a serious concern of every country. So, the new pests, the entry of new diseases, so it have far reaching consequences on the environment as well. So, the risk assessment is all a part of the entire process. So, the risk assessment specifically you can see that it look into the evaluation of likelihood of entry, establishment or spread of pest or diseases within a particular territory from the importing country, then adoption of certain SPS measures or other consequences, economic consequences, or the evaluation of potential adverse effect on human, animal and plant due to the presence of additives, contaminant, toxins, disease causing organisms, foods, beverages, foodstuffs, etc. So, the contamination or contaminants, additives, toxins, all these categories will come under the risk assessment procedures. and how the risk assessment from pests and diseases is made. So, we already mentioned about the Australia salmon WTO case in 1998. So, the panel and appellate body in different cases has made directives, directions or clarifications on how this risk assessment is made. So, in the Australia salmon case, so salmon everybody knows the fish, the risk involved likelihood of pest or disease establishing and spreading. So, the potential biological and economic consequences to be taken into consideration for the risk assessment. And two, so can a particular country ban a particular fish or the frozen fish allegedly by saying that it carries a number of diseases. So, you can see that the Canada claimed that imported for human consumption was unlikely to lead to the introduction of any such disease. Always the exporter will argue that there is no risk, but always the importing country argues that there is risk. This has happened in US, EU beef hormone case also. So, it is the burden of proof is with the respondent or the exporting country to prove that, or it is the duty of the importing country to prove that, scientifically to prove that this is harmful. So, whether it is fish or it is beef or it is biotech products, it is the importing country to prove that, scientifically prove that this is a risk. This is the risk to human health or animal health or plant health. So, we talked about too much talked about the EU beef hormone case. So, in this case also the appellate body very clearly said, the panel and the appellate body very clearly said that, so the European communities did not provide any evidence that the studies or the scientific conclusion reached therein have actually been taken into account by the competent EC institution, either when it enacted those measures in 1981 to 88 at any later point in time. It clearly says the meat product treated with hormones are not inconsistent with the SPS agreement. So, that means meat and meat products treated with hormones should be allowed by the EU. So, EU ban is inconsistent with the SPS agreement. So, without scientific evidence, you cannot import you cannot put a particular ban, a blanket ban on the import of any product, whether it is fish or it is beef. And so, we were talking about the hormone case, right. So, the beef from hormone treated cattle. So, the main argument of European Union was this causes a threat to the human health. So, the appellate body of the WTO dispute settlement system has applied a two-step test for the assessment of foodborne risk. So, this entire jurisprudence is based on the risk assessment. So, one, identification of the adverse effect on human or animal or plant health arising from the presence of particular additives, contaminant, toxins, etc. So, first you have to identify the adverse effects on human beings or animal or plant. 2, such adverse effect exists, evaluation of the potential occurrence of these effects. So, the identifiable risk, and that risk need not be qualified, but can also be expressed qualitatively. So, the risk must be identifiable, otherwise you cannot put a blanket ban on the import of any particular products from another WTO member country. So, the risk assessment and the production of scientific evidence is always lies on the importing country. And another case, another famous case is the biotech case. So, the biotech producing countries like US, Canada, Argentina They have complained to the WTO, the panel and appellate body, saying that the EU again ban on the genetically modified organisms, ban on genetically modified organisms, especially food items. So, this was imposed, the European Union imposed without scientific evidence. So, what is the limit? Definitely the members can adopt standards, but not blanket ban without scientific evidence and risk assessment. So, in this particular case also the European Union lost the case, because they were not able to produce sufficient scientific evidence. So, scientific evidence is an important component, very important component in the risk assessment. And we said that the countries can adopt an appropriate level of protection or acceptable level of risk or even a higher standard based on risk assessment and scientific evidence, and cannot be adopted as a means of trade barrier. So, in the biotech case and also EUB41 case, the panel and appellate body said that the European Union used these measures as a trade barrier and struck down the measures taken by the European Union. So, when it comes to the animal health, so we know that animal health, whether it is the sardine case, Australia salmon case, which we already discussed about, fish, fauna and flora, and risk from injury, spread of diseases or disease causing organisms, all these are a risk, including is even pest or diseases can be carrying with the animals. So, we talked about these three organizations which talk about the Codex. So, the WTO SPS agreement urges the members to adopt the international standards adopted by the three sisters, that is Codex, IPPC and OIE with regard to food standards, plant standards and animal standards. So, these international organizations develop international guidelines on risk analysis. So, risk assessment, risk management and risk communication, 3-step process which they are developed by these international organizations with regard to risk assessment. So, the factors, what are the risk assessment factors? The risk assessment factors in the SPS agreement, it does not prescribe any particular risk assessment methodology, but Article 5(2) you can find certain factors to be taken into consideration by the members in the risk assessment. What are those factors? Available scientific evidence, relevant process and production methods, inspection methods, sampling and testing methods, prevalence of the specific diseases or pest, existence of pest, disease or free areas, ecological and environmental conditions, then quarantine facilities or quarantine and other treatment facilities. These are the factors to be taken into consideration for risk assessment, which is mentioned under the Article 5, but I said that Article 5 does not prescribe a particular methodology for risk assessment, and these are the factors. And also the risk assessment factors, certain measures to be taken into consideration. What are those measures or certain things to be taken into consideration? They are and do not need to be quantitative in nature. The risk assessment need not be quantitative in nature. So, it must be ascertainable actual risk. So, it must not be the future risk, it must be ascertainable and actual risk. It should be specific should not be general. So, analysis of the risk in the real world, that means beyond the laboratory conditions. So, and also no requirement to carry out own assessment, and divergent minority views from qualified sources are also acceptable. The need to revisit if science is involves. So, science evolves, that means the scientific investigation evolves, the reasoning also may be different. So, the risk assessment, these risk assessment factors to be taken into consideration. So, we talked about risk assessment factors under Article 5, and in the easy hormone case, the panel and appellate body clearly said that the members not required to base their measure on quantitative risk assessment. Qualitative risk assessment is qualitative risk assessment of potential risks are more than enough. So, that means, so a numerical expression or quantitative result is not required under the risk assessment. So, this is held in easy hormone case, and also you can see that say ascertain actual risk to be assessed. The theoretical future risk is not the kind of risk which they are looking under Article 5(1). And also you can see that the risk covered should be of specific to the situation, risk at hand, and it is not sufficient for risk assessment to identify a general risk, and general risk is not the subject of SPS agreement. A specific risk is to be there, taken to be identify a specific risk or a harm and address that risk. So, and this is held in Japan Apple case. So, the panel and appellate body is also clear with regard to the clarification of points what exactly constitutes the risk assessment and risk assessment factors. And also you can see some of the points held by the panel and appellate body. So, it said that it is beyond the actual conditions, it may not be in the laboratory conditions. So, the risk may be different in laboratory and risk may be different in real world situations. So, the real world situations are only taken into consideration, not the laboratory situations. 2. So, and every members are free or they do not also need to carry assessments, and the assessments done by other members also can be adopted, or the risk assessment done by the international organizations can be adopted by any members. So, every country need not do a complete or elaborate risk assessment. If other countries are done, they can adopt it, or if the international organizations are done, then they can adopt the international standards. And also, so the mainstream scientific opinion, there can be a divergent scientific opinion, a minority opinion from a well qualified people, that also should be respected, that also should be taken into consideration. And then again, SPS measure cannot be maintained without sufficient scientific evidence. So, that means scientific evidence, risk assessment, and it should be together, and you cannot impose any SPS measure without scientific evidence and without an risk assessment is undertaken. So, all these points are clarified by the panel and appellate body in easy hormone case, and then Japan Apple case and easy biotech case. So, these are some of the important WTO cases relating to the risk SPS agreement, risk assessment. Then approval procedures. So, every government must have a testing facility, inspection facility and approval procedures. So, sanitary and phytosanitary regulations and there must be inquiry points for the dissemination of information. There must be inquiry points for SPS and TBT for the dissemination of information, and specific offices should be designated as SPS offices and TBT offices, and we will see the addresses of Indian offices. So, the implementation is specifically given to the central governments of every member countries, because different standards may be adopted by the constituent units of a state at the lower level, but the implementation is to be done by the central government. So, the implementation is to be done by the central government at the domestic level, at all levels in the entire territory they have to be implemented. So, the inquiry point is to be made by the central government and a notification is to be made by the central government. So, the implementation of SPS agreement is to be completely with the central government and its constituent units. So, the domestic authorities must publish all regulations and rules relating to the SPS agreement, and they should report to the SPS committee, and also the copies to be provided of such regulations, and then the copies to be given to the people those who are asking for it. So, complete transparency. Inquiry points. The objective of inquiry points are very clear. This is a part of transparency, and also designated authorities, designated officials, mainly relating to the people want to know about risk assessment procedures and also other process which they have to follow, and also definitely to following the international standards or dissemination of information with regard to international standards developed by the international organizations. So, we talked about international standards, the three sisters organizations which we already talked about it, and they talk about standards, food standards, additive standard, veterinary drug standards, pesticide residues, contaminants, method of analysis of sampling, and guidelines for hygienic practices. So, all these are done by the organizations like Codex, and OIE, Office of International Death Episodes. So, international, this World Animal Organization, World Organization for Animal Health, OIE, they also do the same systems. IPPC, which develops standards, guidelines and recommendations for the entire to protect the plant health. And if you look into the inquiry points, you can see inquiry points for every office, every points. For example, in India, SPS office is, so you can see the address, a specific address is given and a specific email also is given of the particular officer. And if you look at the food safety, there is very clearly mentioned about the offices for international food safety. So, what is the address, what is the phone numbers, and what is the email addresses for food safety. Animal health also is specifically given the points, inquiry points within India, and plant health. So, plant health under another ministry, Ministry of Agriculture, and so there also the specific person address and inquiry point is given. And even you can see the Codex, who is in charge of the Codex matters, international standard matters. So, the Government of India has now made different offices to take care of these particular risk assessment and related assessment or other standards or other process which is relating to this SPS agreement. And so, we can see we talked about risk assessment and animal health. Animal health also there is an office, a designated office as a part of the inquiry points which is mentioned. Plant health, which we already said that it is already included. So, now we look into the SPS. Now, so some of the risk which we can see that is transgressing into the TBT, the packaging. the labeling and packaging side as well. So, that we will discuss maybe in the coming classes about the TBT. So, what is this inquiry points are actually doing? Inquiry points are the points designated authorities to do and explain on all questions reasonable inquiries and provide relevant documents, technical regulations, standards and conformity procedures with regard to SPS agreement, whether it is food safety or food standards or animal safety or animals, the standards for veterinary drugs or even plant health, disease and disease causing organisms. And these inquiry points are very clear. So, they can participate in the regional standardizing bodies and assessment mechanisms and testing arrangements. So, basically the function of inquiry point is to provide sufficient information, and they do the dissemination of SPS and TBT related materials, preparing basic the position of the country on these notifications, arranging workshops and awareness programs, and also do training programs, and also do the alert services. And inquiry points which we have already talked about, which we talked about this, and the departments concerned. There are India 3 departments are concerned about the implementation, that is the Department of Commerce and the Bureau of Indian Standards. So, the designated authority for the TBT inquiry point in the Ministry of Commerce, then a Ministry of Health and Ministry of Agriculture, SPS inquiry points. See, these are the 3 ministries responsible for the implementation and other related matters on SPS. So, one more point which we have to see is the Codex, because why the Codex is important? The Codex Alimentarius Commission is the international standard making agency for food items. So, they make standards, they make codes of practice, and they make quality standards, and also they make international food standards. So, these Codex standards are widely adopted by the members, uniformly adopted, and these standards are made after an elaborate risk assessment based on scientific evidence, and they form the fair practices or good practices. So, the consumers can trust the safety if somebody is adopted the Codex standards. So, Codex is making international standards, standards for foods, processed foods, semi-processed foods, raw foods, and which is directly the materials which is distributing to the consumers. So, the Codex prepare the standard based on risk assessment. When it comes to other animals, you can see they not only talk about food hygiene, food additives, residues, the maximum pesticide residues, veterinary drugs, contaminants, labeling and presentation, methods of analysis and sampling, and also the import and export inspection and certification mechanisms. So, every country have now export and inspection mechanisms. India also have export inspection and certification mechanisms. Still thousands of consignments are rejected every year. So, it shows a very pertinent question, the effectiveness of these particular organizations. One of the largest membership is there in the Codex Alimentarius Commission with 189 Codex members. So, it is not 189 and 189, 188 plus the European Union and a bunch of countries. So, this is one of the international organizations with the largest membership. And in conclusion, I would say that animal health, the human health, animal health, plant health are very important. very important health concerns of consumers, because we saw in the beginning that in some of the there is a lot of consignment rejections, foodborne diseases, foodborne risk to the human health and threat to animals, threat to plants, and so there must be reasonable restrictions, reasonable barriers and reasonable standards in each and every country. So, I said in last class also, if you are not adopting a standard, a higher standard, it is your problem, and you cannot impose importing materials a higher standard and a lower standard for domestic producers. So, the largest number of rejections shows that there is some problem. There is some problem in the standards, some problem in the risk assessment, some problem in the certification and inspection schemes, which each and every member has to be taken into consideration. And SPS never imposes a uniform standard. It never imposes a uniform standard, and every member country is free to adopt their own standards. So, we discussed elaborately about the risk assessment, and risk assessment is an important factor, very important factor in scientific evidence. Come to the scientific evidence and to make SPS measures. So, whether it is European Union or other country, if any SPS measure is not in accordance with or not complying with or not produced sufficient scientific evidence and risk assessment procedures, then you cannot ban any particular product. You cannot ban any particular product from any country. So, we can find more number of cases, whether it is salmon case or it is apple case or it is EU beef hormone case or it is EU biotech case, and you can see a sizable number. That is why I said that thousands of SPS measures are reported by every country every year. So, human health, animal health and plant health is very important for every country and everybody to adopt international standards. So, this risk assessment and scientific evidence is the core heart of the entire process. And in the next class, we will talk about some of the other institutions, other processes related to the SPS agreement. Thank you.